All right, it's 12 o'clock, so we are going to begin the webinar. Welcome, everyone, to the primer on the state court judge's role in special immigrant juvenile classification. This is the first in a series of 2 webinars on SIJS, sponsored by the ABA Working Group on Unaccompanied Minor Immigrants and co-sponsored by the ABA Judicial Division. I'm Christina Ritchie-Cooper with the ABA Center on Children and the Law. With us today to present are 3 presenters. The first is Honorable Katherine Estrin, who serves as a circuit court judge in Florida's 13th Judicial Circuit in Tampa. She's currently the administrative judge for her circuit's Unified Family Court, as well as the administrative judge for that court's Juvenile Dependency Court. Angie Junk is a supervising attorney at the Immigrant Legal Resource Center in San Francisco. The ILRC is a nonprofit that provides legal trainings, educational materials, and advocacy to advance immigrant rights. Angie specializes in issues related to immigrant youth, the immigration consequences of crime and delinquency, and immigration enforcement. Additionally, Eileen Matuzek will be presenting. Eileen works for the U.S. Citizenship and Immigration Services agency, the federal agency that adjudicates SIJS applications. She works at the SIJS Office of Policy and Strategy on policy, regulations, and outreach related to the SIJ program. I will note that the presentation by Eileen that's offered by USCIS will not be recorded and can't be distributed. So the PowerPoint that you see here and Eileen's presentation that you will hear will not be available when we post this webinar and related materials online. We will include additional SIJS eligibility and some other materials for review later on, and we'll add another portion to the recording. However, again, the USCIS portion of this presentation will not be available after the live presentation today. The recording and materials will be available at the websites you see in front of you. Those are the sites on the ABA website for the Center on Children and the Law, and the Working Group's website on Immigrant Children Advocacy Network. So with that, I will turn over the presentation to Angie Junk. Angie?
Thank you. Hope you can hear me well. I'm going to speak about an overview and context for who immigrant children are, some federal definitions, some background on why they come to the United States, and the forms of relief available, and the particular role of state systems in special immigrant juvenile status. So just to begin, in terms of looking at the bigger picture of immigrant children in the United States, approximately 23.2% of children are either immigrants or the children of immigrants. And many of these children may be actual citizens but have parents that are undocumented and be involved in state systems. But for today's discussion, a lot of what we'd like to discuss is really about children who are without legal status or undocumented. And we really want to highlight the fact that despite, a lot of news about unaccompanied minor children, that there are all sorts of children with different backgrounds that are undocumented within the United States that may be found in state systems. And some of these children may have grown up almost entirely in the United States, coming here at a very early age, as a toddler, and they consider this country their home. We've seen many of these children throughout the United States in dependency proceedings, potentially delinquency, or other kind of state court proceedings. That they are just as vulnerable as well because many of them no longer have ties to the home country. Many of them no longer speak the language of their originating country where their family has come from. And many of them may be even unaware of their lack of legal status. The other group, and this has been more widely publicized because of the unaccompanied minor surge in the last year, is children who have come to the United States more recently, whether it's in the last year or in the last several years, fleeing violence, abuse, or other harm. And these children may be completely alone, but some of them may have come with a parent or parents. And we're seeing that many of these unaccompanied children, the reason why they are residing here in the United States after being apprehended at the border is because they have family, is whether it's parents or other extended families, aunts, uncles, brothers, and sisters with whom they can be reunited with. We went on to provide a federal definition of the unaccompanied minor. And this is a term that's quite frequently used when we talk about who these children are, even as they relate to state court systems. And it's a child who is undocumented, so they have no lawful immigration status in the United States. They must be under 18 years of age to be still classified as unaccompanied minor under federal law. And then finally, the key element is that they don't have a parent or legal guardian in the United States that is available to provide care and physical custody, at least when they are apprehended. I do want to highlight here, while this term seems to have always kind of related to many of the minors who have just crossed the border and are in federal custody before they actually enter and are relocated to local areas with family members, the federal government classifies most undocumented children throughout the United States as unaccompanied minor. So what that means is that the children that I described to you before that may have been living with their family and parents since a very young age in the United States, if they are reported to the federal government in some way or another, many of them, what we see, are classified also as unaccompanied minors. So the unaccompanied minor population is quite diverse in terms of who might fit in that category. If we just focus on unaccompanied minors and particularly kind of the recent influx that's really driven maybe some of the numbers within the state court systems, we're looking at primarily children from the Northern Triangle. Again, as I said, that doesn't exclude unaccompanied minors coming from India, other parts of Asia, Mexico as well. But many of them are coming from Guatemala, El Salvador, and Honduras. An interesting fact is that in the last year, particularly in 2014, there was a shift in demographics with an increase in the number of females and girls, as well as an increase in the number of younger children under the age of 14 years old. So that's kind of the look of unaccompanied minors, and I think that, as many of you know, what's brought great attention to this is really if you look at these numbers of kind of the doubling of numbers every year since 2011 there. And we definitely have had a decline in this year, but our reports from some of the service providers within the federal government have said that there has been an increase recently in the last couple of months. So it still has not reached, obviously, the numbers that we saw last year. To give a little context about, why these children come here, and this is important because this is how some of these children fit within Congress's intent to provide humanitarian relief to vulnerable populations, including children. And children have many reasons for coming to the United States, and this is why there's many different lenses to legal claims for which they may assert in the immigration context. But particularly with unaccompanied minors that we saw in the influx last year, many of them really cite increased violence in the Northern Triangle, gang, cartel violence as really a primary motivation for them coming to the United States. And that's not to say that there aren't other reasons that exacerbate their situation, including poverty, the lack of work and ability to even have home in their home country, as well as family abuse, neglect, and abandonment, which is really the focus of our call today. And then finally, just the desire to reunify with other family members, even if it's, maybe a parent or other grandparents, sisters, and brothers that may be residing in the United States. I've provided a few slides here. We won't go through all of them, but there's been a lot of reports, as probably many of you have heard about, some of the motivating factors of these children. And I just wanted to highlight this because I think what is embedded in many of these case stories is just a history of great trauma. Many of these kids have seen great violence and seen family members or other friends and people in their neighborhood shot and killed in front of them. Many of them have been direct targets of these exact threats and may have been physically harmed by gangs. Many of them also have been beaten and suffered from domestic violence within their own homes. And so for many of them, the trauma is not only compounded by what's happening in the home country, but by the risk and the dangerous journey that they embark upon to get to the United States, where many of them suffer additional harm through smuggling networks, cartels that are actually now working with all the smuggling networks as well. If you can go to the next slide, I do want to just read one quote about kind of the drastic view of life that some of these children face. And in this report by the Women's Refugee Commission, they state that despite the horrific conditions that some of the children underwent in making the journey to the United States, the majority stated that they would still make the trip even with the knowledge of how difficult the journey was. As one child explained, if you stay, you will die. If you leave, you might. Either way, it's better to try. So, really I think some of the motivation for many of these children is just the will to live and to seek any means in which to be able to do that. I'd like to turn into kind of looking at the humanitarian relief and how this trauma and their experiences of violence may form these beliefs, some of the protections under both international and domestic laws. And so the UNHCR data has shown that no less than at least 400 children that they had interviewed in last year was that, no less than about 58% of those children suffered or faced harm that indicated a potential or actual need for international protection, which we're really talking about asylum. And for these reasons, many of these children are willingly turning themselves over to Border Patrol upon arrival in claiming some of those claims. Because of the forms of violence that many of these children have suffered, as well as the trauma, they may qualify for different forms of relief. I know today, again, is the focus on special immigrant juvenile status, we'll discuss in a moment, but it's important to note that, because of the different experiences these children have, they don't necessarily always just fit in one bucket of relief, although some may be stronger and easier to prove for some of these children facing deportation. I think the obvious one is just claims of past persecution and well-founded fear of persecution in their home country. The other one that's obvious that we're talking about today is special immigrant juvenile status. It's not only the fear of general environmental conditions, gang violence, cartel violence, but really the fear at home that these kids experience from abuse, neglect, or abandonment by a parent or both parents. Other cases, we're seeing this less likely, but I think there will definitely be increases what we call the U visa. This is for any victim of crime in the United States. So some of these children, that once they are settled here in the United States, may be targets of crime in their neighborhoods, maybe even from family members from domestic violence or other abuse. And then finally is the T visa, which is a trafficking visa for labor or sex trafficking. Some of these children may find themselves in a trafficking situation, even reunited with family members or others who are used to exploit them. Many of these children have these experiences as they cross the border, where they're caught up with some of the cartels. They're forced into trafficking situations, even with their smugglers to pay off debts, debt bondage. So those things are important to look out for, as many of these children have been caught in those situations. And again, it's just to emphasize, while we're focused on special immigrant juvenile status, many of these children, because of the different lenses of trauma and violence that they have suffered, may be eligible for multiple forms of relief. So my last section here is just to kind of highlight the special immigrant juvenile status and just kind of set this up for Eileen from USCIS to talk more deeply about this. But special immigrant juvenile status is really for children that may be under juvenile court jurisdiction, defined broadly as any court that has the authority to make decisions about the care and custody of a child, which is defined under federal laws under the age of 21. So there is a little bit broader than what many state court systems define. And it's really for children who have been abused, neglected, or abandoned by one or both parents, and it's not in their best interest to be returned to the home country. And this is really a two-step process. But for purposes of what I would focus on right now is that, the reason why it's so important for us to do this outreach and speak to court and state systems and people working within those systems is that While immigration is typically a federal issue, Congress has directed state juvenile courts to make the factual findings that establish the basic eligibility for special immigrant juvenile status. And I can't emphasize that enough. Without these state court findings and the assistance from state court attorneys and others to flag these cases, then these children may not even have the opportunity to even apply to the United States Citizenship and Immigration Services, which is the agency that adjudicates these petitions. And so that they don't even have an opportunity to see if they can legalize their status and have more stability here in the United States. It's just a background of like, who is this intended for, and how is the history through even Congress's amendments to SIJS contemplated this relief for children and who may be eligible for it. And just a brief history is that, this was established in 1990, shortly after the 1980s legalization. And really the goal was that there was an inability for children to petition under a family-based immigration framework when they were in the foster care system. The federal government would not accept the foster care system, which was really legally their parents, from petitioning for them to get legal status. And this is how SIJS was born. And the key things to note here is the language at that time that was adopted really relied on a kind of dependency child welfare framework, as it relied on the child being declared dependent on the court, as well as the court finding that they are deemed eligible for long-term foster care. So in that way, it was really designated at that time for children in the foster care system. In 1997, there was some limiting language added, which was really to get at that it wasn't only for children in foster care system, but that they wanted to make sure that these children also were proven to be abused, neglected, or abandoned, that there was actually some finding that could be made that was what was happening to them. Even though there's this language around the foster care system and in the statute through USCIS regulations and memorandum, children who were in adoption proceedings, even children in guardianship, as well as children who found themselves in delinquency, were, to a certain extent, maybe not as much, applying for special immigrant juvenile status, and they were being adjudicated and approved through the federal government. So that was something that, despite what the statute said, was seen more broadly. And that's where it got us to 2008, where we see the Trafficking Victims Protection Reauthorization Act. And that really expanded greatly, the statutory language. In some ways, I think a lot of people saw to reflect the practice and to even expand the practice and understanding of who was eligible. And I think it really recognized that the vulnerability of certain classes of immigrants, whether even just women or children, and showing that even the children that have been abused, neglected, or abandoned do not just fall within a dependency system, that you cannot depend on them just falling into one state court system, that these children exist in many different places, and that's not a reason for Congress not to provide those same similar protections for them. And so that's why they took up the language around long-term foster care. They added language that allowed state courts to even have jurisdiction over these cases when they appointed a guardian or they are, assigned to the custody and care of an entity or state agency like probation departments. So that makes it much broader. And they were open to saying, look, a lot of states don't define this as abuse, neglect, or abandonment, but there may be similar definitions. And so there are other ways in which children may fall as well. So that's really the history of special immigrant juvenile status, and expanded greatly in terms of the intent. And so just to wrap up, I think this is really showing that there's really broad coverage of the breadth of the statute. The consequence that there's a number of clients that can make a number of courts that can make these findings, from delinquency to guardianship to dependency to what we're seeing now, family courts, guardianships, and even courts. Some other courts are labeled district courts or courts of general jurisdictions. It's not limited to certain labels if any of the courts have the authority to make decisions about the care and custody of children. And to that end, there are a number of children that people may not think that typically are eligible for SIJS, but have been approved. And just to give you a few examples, they can include children in the child welfare system who are even living with one parent when the other parent's reunification service has been terminated. So this is the one or both parent language because there has been a finding of abuse, neglected, or abandonment by one. It could include a child that's unaccompanied, like we talk about, and is now residing maybe with an uncle who has petitioned to be his guardian. It can be children in delinquency. Maybe a child came here at the age of 6, is in the delinquency proceedings, has been placed on probation, but cannot be reunified with his mother because of an abandonment. And then I think finally, this could be a child who came and there's abuse by a family member in the home country, but now is safely living and reunified with the mother here in the United States, where there is sole legal custody. So these are kind of the different phases of SIJS that are definitely qualify under the federal statutes that have been approved. And so it's important, I think, for us to make sure that we're flagging these cases, as this really provides greater protection to vulnerable populations throughout the U.S. Thank you.
Now we'll turn to current eligibility requirements for SIJS. For a youth to be eligible under SIJS, he or she must be under 21 years of age, be unmarried, have been declared dependent on a juvenile court located in the U.S., or the court has committed the child to placement under the custody of an agency or department of the state, or to an individual or entity appointed by a state or juvenile court. Additionally, the juvenile court must find that reunification with one or both parents is not viable due to abuse, neglect, or abandonment, or a similar basis under state law, and that it's not in the young person's best interest to be returned to his country of nationality or last residence. A few notes on those requirements. The youth needs to be under 21 years of age when applying to USCIS for SIJ status. However, many state courts lose jurisdiction over a child when the child becomes 18. So the youth does need to receive or obtain this order with the predicate findings from a state juvenile court before turning 18, and can then take until he or she is 21 to apply to USCIS at the federal level. While the youth does need to remain unmarried or be unmarried and living in the U.S., having a child is not a bar to SIJS applications. There is no longer just a dependency requirement in these findings. The youth may also have been placed with an agency, as in a dependency or a delinquency case by a state court, or place or custody assigned to an individual, whether a guardian, a relative, another caregiver, or a parent, including the parent who is the non-abusing or non-neglectful parent. That is a change based on the 2008 amendments to the law. Reunification can be possible with one parent and not with both parents under the current eligibility requirements, and based on the past abuse, neglect, or abandonment. And that maltreatment can have taken place in the U.S. or outside the U.S. The court must also find that it is not in the best interest of the youth to be returned to his or her country of nationality or last residence. The court can consider detriments to the child returning to the home country and benefits of the child staying in the U.S., including physical, mental, educational, or other benefits. All these elements must be met for the youth to secure SIJ status at the federal level. USCIS has noted that orders with these findings should include the factual bases of the findings and not just parrot the statutory language regarding SIJS. For a child to access SIJ status or be granted SIJ status, there are a series of 3 steps, really. The state court order with these 3 predicate findings is the first step. Then the youth may apply for a SIJ visa through the form I-360 with U.S. Citizen and Immigration Services, or USCIS. And then the youth also must apply for an adjustment of status or a green card using a form I-485 with USCIS or Immigration Court. More information about that process can be found on the USCIS website as well as ILRC's website. So in the interest of time, since we just have about 15 minutes left, I'm going to jump ahead and ask Judge Estrin to share her thoughts on the court's perspective. And then after that portion, we will address as many of the questions about the state court process as possible. So Judge Estrin?
Thank you. Can you hear me?
Yes.
Very well. I'm going to be brief because it looks like we have lots and lots of questions. But as we pointed out earlier, we are doing a second part of this presentation in December. So any questions we don't reach today, or if you have any additional questions that you come up with between now and then, we will certainly try to answer them. I know a number of judges, both in my jurisdiction and throughout the nation, are troubled by their role in this process. And one of the things that I've noticed when we've done outreach locally is that there's a concern by state court judges that we're, quote unquote, being used, or that we're exceeding our authority, and there's just a discomfort that comes with the unknown and what is different from what we normally do in our day-to-day roles as state court judges. So I want to say to you, as somebody, I'm in Florida, where we've had a number of these cases, that you don't need to be afraid of this process. A lot of it just comes from education, and as you've heard from Angie and Eileen's presentations, there are a number of resources out there that are available to all of us. And I would also recommend to those of you, particularly if you're an administrative judge or you have any sort of a leadership role in your jurisdiction, that you undertake some things to assist your fellow judges and perhaps yourselves in becoming familiar with this process. And I would emphasize and ask that you always be mindful of the fact that as state court judges dealing with juvenile issues, this is what we do on a day-to-day basis. And there's when you look at the big picture, there's no difference. We're looking at things such as safety and well-being and permanency. And it's no different in these SIJS eligible children population that we're dealing with than it is in any of our other populations that we deal with. So just keep that in mind, and also sort of look at why it is that we're asked to do what we're asked to do in these cases. As I said, there are a number of ways that you can educate yourselves and your fellow judges in your jurisdictions. One of the things that we did in my local jurisdiction when we were anticipating that we were going to have a large increase in the number of unaccompanied immigrant children coming into our jurisdiction was we put together a work group, and there are lots and lots of people involved in this work group. And we put together a flyer in both English and Spanish, and we posted, not only on the flyer, but we posted on a website on our Center for Child Welfare at our local university, a list of what resources are available for any immigrant children in our area, in our geographical area, where they can get free or low-cost legal services, medical care, information on medical insurance, all those types of things, school information that they might not otherwise have information on. So I would recommend if you can do that. We get together as a group every other month, and it's been terrific in terms of doing outreach and answering questions and providing general guidance, not just for those in the child welfare system, but for immigrant children in our county generally. And feel free to contact me if you have any questions about that, or if you'd like a copy of what we put together if you want to use that. So one of the things that I hear over and over again is the discomfort with feeling like, as a state court judge, I'm being asked to decide federal matters or go outside my comfort level, because why should I, as a state court judge, have to deal with immigration issues or be concerned with immigration issues or what have you? And there's this sort of inherent tension. But you need to understand the roles, and I think both Eileen and Angie pointed it out to some extent. But there really is a major difference in the federal immigration system and the state court system. The federal government is charged with determining who should remain in the United States and for how long and under what circumstances and conditions, who should not be in the United States and why, who should become U.S. citizens and things such as that, whereas state courts deal with issues such as punishment, rehabilitation, restoration or making victims whole, protecting the vulnerable, adjudicating disputes, and providing justice in individual cases. So there is a very different role that each of those systems plays. And keep in mind, and both Angie and Eileen have pointed this out, but just remember that we in the state courts do not adjudicate immigration status. We do, however, as state courts, provide equal access to justice for all. And as a general rule, federal immigration law does not consider the things that we as state court judges consider. Federal immigration law does not consider best interests of children. Neither the Federal Immigration Court nor USCIS has the ability or the resources to do the kinds of investigations or to make the kinds of determinations that we in the state courts determine. So they look to us in making their determination with regard to immigration rights of parents and children. They look to us in the state courts to determine what is in the best interest of a child. And so it is absolutely our job as state court judges to provide that guidance, to provide that information, and to make those determinations as to what is in the best interest of the child. And then what the federal government does or does not do with our orders is up to the federal government. We are not making those decisions. And I think it's really important to remember that in making our decisions on these cases. One of the things I want to talk about, and I know we don't have much time here left today, but one of the things that really seems to bother state court judges, and I think it's clear from the earlier presentations, what our orders, if you do find, based on the facts and circumstances presented in your case and based upon the state law where you reside, if you do find that the burden has been met and you do want to enter an order, you do want to make sure that your order is correct. And in order to be correct and in order to be what is useful to the child in their federal proceedings, you must have the three elements that we've talked about before. You know, one, that the juvenile has been declared dependent on a juvenile court or has been legally committed to or placed under the custody. I don't have the specific language right in front of me, the custody of an agency or department of the state or an individual or entity appointed by a state or juvenile court of the U.S. Two, that reunification with one or both parents is not viable due to abuse, neglect, or abandonment. And three, that it would not be in the child's best interest to return to his or her previous country of nationality or country of last habitual residence. And that's one of the things that we really struggle with as state court judges sometimes is the finding that reunification with one or both parents is not viable due to abuse, neglect, or abandonment. Because as was pointed out earlier when you looked at who these children are, sometimes they are residing with one of their parents. And that seems to create a lot of difficulty, particularly for dependency court judges, that they don't understand how you can find that reunification with one or both parents is not viable due to abuse, neglect, or abandonment if, in fact, they're residing with one of their parents. And there's been a number of decisions throughout the country. Different states have held, but I would suggest to you, and I know there are some states, particularly there's a decision in Nebraska that is different from what I am going to suggest to you, but I would suggest to you, and I think the vast majority of the states who have interpreted this language would agree with me. I know those in California, Illinois, Minnesota, New York hold that non-viability of reunification with one parent is sufficient to meet that one or both language. And I think it's very clear, even though it's a bit of an awkward way of wording it to say that reunification with one or both is not feasible or is not viable. But I think it's clear that they could have said reunification with neither parent is feasible or viable, if that's what was meant. And that's not what was meant. The situations are very clear. Sometimes you'll have a child who was abused in his or her country of origin come to the United States and at some point finds a parent who's been in the United States who perhaps didn't even know this child existed. I've had situations such as that. But regardless of the factual circumstances, you can have a child who has come to live with a parent who is not a risk to the child, who has not abused, abandoned, or neglected that child. And so long as you find that reunification with that other parent is not viable, in my humble opinion, you have met your the statutory elements, and that's all that's required. So long as you have one parent with whom reunification is not viable due to abuse, neglect, or abandonment. So I know that I'm looking, I haven't been able to read while I've been talking, but it looks like we have a number of questions. So I'm going to turn to Christina as to how you want to handle these questions.
Thank you, Judge. We do have a number of questions in just a few minutes remaining, so I will pose a few to our presenters, and I will note that I'm prioritizing ones I think can be answered in a few minutes, and the rest will be considered and saved for our December 8th webinar, during which we'll hope, Judge Estrin, that you're willing to start off so you can answer as many as possible at the beginning. And again, I'll remind people that what we will continue on December 8th is this webinar series devoted to informing state court judges about the state court process regarding SIJS. So those are the questions that we will try to prioritize. But Judge, you did speak to the difficulties of getting custody or perhaps guardianship orders when the child is with one parent. If our other presenters have any other comments that they'd like to share, please go ahead and do so now about the one-parent cases. And if not, I'll move on to another question.
This is Angie. We actually worked with, did a survey a couple of years ago on this issue with service providers that were funded through the federal government for ways to do Know Your Rights and working with these children and their nonprofits. And they had reported, many of them had reported hundreds of cases around the one or both parent issue, many of which they filed and were approved by USCIS. So in practice, I can confirm what Eileen is saying, that these have been accepted from states across the country. Thank you.
Another question is whether if the youth has a relative who is undocumented but can be appointed guardian, does the child have to be found dependent, abused or neglected, and does the foster care agency need to be involved in that matter?
So I would just be...
Go ahead.
I think we're just trying to make clear here, though, it's not just dependency courts that can make the abuse, neglect, or abandonment findings. I mean, that is something that every state court could look at, but in some states, you have multiple different kinds of courts, whether guardianship, family, that are making those findings. And so I think we're not advocating for anyone to enter into the child welfare system if there's not a need in terms of, the need for care, especially if someone's residing in a safe place. And that's why I think many of these children may be going instead to family court or guardianship because they may be already living with a family member who is seeking a legal determination from that court for other reasons, not just because the child is at risk, but because of issues around legal, physical custody, or just declaring a family member or guardian so that they can make decisions for that child when they're living with them.
This is Judge Estrin again. I think, I think what the question is getting at, and I certainly can relate because we have a number of cases like this where I sit in dependency court, where the child is already with a relative who is undocumented, and again, that's a little different from the scenario we normally see. Normally when we place a child with a relative or a non-relative in dependency court, there's been a home study done, and it has to have been approved by the state, and they might or might not have actually approved in a different type of case a home with someone who's undocumented. I think in these cases, or at least from my perspective, when I'm handling one of these cases, if I feel that the child is safe, if I feel that the sponsor is providing appropriate care, the fact that he or she is undocumented, and therefore, I think what is implicit in this question is the child, perhaps the undocumented relative with whom the child is residing might be arrested or deported, or there may be some adverse consequence from the fact that they're here illegally, perhaps that you should involve the child welfare system. I don't think there's any necessity to do that. If I have a comfort level, and that's my job in making these decisions in these cases, but if I have a comfort level that individual, that relative is providing a safe and appropriate home for the child, I don't put services in place. I certainly don't put the child in the foster care system. If later on the circumstances change and the child becomes dependent because something happens to that relative or sponsor, then that's something that certainly our system can deal with. But I don't feel like just because I'm protecting a child from abuse, abandonment, or neglect by a parent that occurred in some other country, that I should keep them from otherwise appropriate, loving family members who are in this country, albeit perhaps undocumented.
Thank you, Judge. And I will just add, to reiterate what we've heard several speakers say, that a dependency official finding is not required because part of the state court order can indicate that the court is making a finding of custody or guardianship to an individual, which is the other part of the question. So thank you, everyone, very much. I'm sorry we were only able to squeeze in a couple questions at the end of the webinar, but it's past 1 o'clock now. We knew that we wouldn't have time to get to everything, but we will do our best to address as many questions that have been asked already and unanswered as possible on our December 8th webinar. And we have my email address is up here where you can send additional questions, but we will save the questions that have been posed during this webinar and try to get to as many questions about the state court process as we can on December 8th. So thank you very much to our presenters, and thank you everyone for joining in today.